Welcome, everyone, to today's webinar on Expedited International Arbitration, Comparative Approaches and Global Perspectives. My name is Rina Soni. I am the Vice Chair of Programming at CIArb NAB, and we're excited to have you with us as we explore the evolving landscape of expedited arbitration and its role in providing a more efficient, cost-effective approach to resolving complex international disputes. Today's presenters, along with those joining us for part 2 of the series in December, have co-authored a book, Expedited International Arbitration, Policies, Rules, and Procedures, recently published by Kluwer Law International. They'll be sharing their insights from the contributions they have made to the book in discussing key topics related to expedited arbitration. This book by Kluwer Law International brings together perspectives from 31 distinguished experts and examines how expedited policies and rules are transforming commercial arbitration and investor-state dispute resolution worldwide. It explores how expedited arbitration policies and procedures impact international commercial and investor-state disputes and examines rules for expedited arbitration across major institutions and regions, addressing the advantages and challenges of achieving efficient, cost-effective dispute resolution. This book can be purchased at a discount today, and I will be posting a link to that in the chat room a little later. Before I introduce our presenters, let me mention that unfortunately our participant, Dr. Venetia Argyropoulos, will not be able to join us today. She has a personal emergency. We send our best wishes to her and look forward to hopefully welcoming her in a future session. And now I will start with introductions. I will first start with Yuan Fang. Yuan Fang is a distinguished scholar in international law, technology law, and dispute resolution. Yuan is currently a JSD candidate at Washington University School of Law, having previously earned his LLM from the University of California, Berkeley School of Law. His doctoral project focuses on the existing international regulatory framework governing cyber operations, examining how to make the contemporary international order a better fit for the digital context through the dynamics between human rights and state sovereignty. Yuan has a range of affiliations that speak to his commitment to international legal issues. He has served as a student ambassador for the American branch of the International Law Association and as a research assistant for the American Society of International Law's Asia Pacific Interest Group, where he works closely with Xian Bao, Vice President of the ICC International Court of Arbitration. Yuan has authored several publications, including works on international cybersecurity, expedited arbitration, and online dispute resolution in China. His recent chapter, examining the practice of expedited arbitration in China, strengths, difficulties, and prospects, addresses the challenges and opportunities in expedited arbitration and offers a unique perspective on China's approach to more efficient dispute resolution. With his expertise and international experience, Yuan brings invaluable insights into the evolving landscape of expedited arbitration in China, exploring both its strengths and areas for growth. We're thrilled to have him today. Please join me in welcoming Yuan Fang. And now I will introduce James Clanchy, our next presenter. James Clanchy brings an exceptional depth of experience in international arbitration with a focus on complex disputes in the shipping, trade, commodities, and energy sectors. Since 2016, James has served as an arbitrator, and since 2022, he has been full-time with over 80 appointments and more than 50 awards to his credit. He is an associate member of 6 Pump Code Chambers in London and a fellow of the Chartered Institute of Arbitrators. James' impressive career spans over 3 decades, during which he has held key roles, including Registrar and Deputy Director General of the London Code of International Arbitration. He's also a former honorary secretary of the London Maritime Arbitrators Association, where he is now an aspiring full member. His expertise extends across diverse international cases, having worked with clients in cases involving countries across Africa, Europe, Asia, and North America. Today, James will share his insights on expedited arbitration procedures, drawing from his experience in both ad hoc and institutional settings under rules such as LMAA, LCIA, and SIAC. Please join me in welcoming James Clanchy. And now, let me introduce to you Dr. Alan Anderson. Alan is our moderator today, as well as our distinguished presenter. Alan is a leader in the field of complex commercial litigation, intellectual property disputes, and international arbitration. With over 3 decades of experience, Alan brings an exceptional depth of knowledge to our discussion. He has represented a broad spectrum of clients, from Fortune 500 companies to small businesses and international entities, in high-stakes matters, including jury trials and arbitration proceedings across the US and globally. Alan's extensive international arbitration expertise is informed by his role as a counsel and arbitrator under the auspices of major organizations such as the AAA, ICC, LCIA, and SCC. A fellow of the Chartered Institute of Arbitrators and the Australian Centre for International Commercial Arbitration, Alan is also listed on the WIPO Arbitration and Mediation Center's list of arbitrators for intellectual property disputes and serves on the panel of arbitrators for the Kuala Lumpur Regional Center for Arbitration. Alan will be moderating today's program and also sharing insights from his book and his vast experience in expedited arbitration, offering strategies for navigating its policies, rules, and procedures. Please join me in welcoming Alan. Gentlemen, thank you for joining us today. Alan, the floor is yours to lead the way. Wishing everyone an insightful session.
Thank you, Rena, and I am going to hopefully here share the screen here so that everyone can see that. Looks like it is. All right, so welcome everyone. Thank you all for joining us. As Rena mentioned, our planned presenter, Venetia, could not join us due to a sudden personal emergency. Hopefully she will be part of the next session in December as an additional sort of bonus presenter there. So I am substituting for her today with a presentation on the recently adopted UNCITRAL expedited arbitration rules. Now, if I can get this to start, let's see. There we go. So as Rena mentioned, all of today's presentations and the ones in December are based off of contributions to the recently published book, Expedited International Arbitration, Policies, Rules, and Procedures. If anyone is interested in purchasing the book, either in hard copy or electronic form, there is a link shown on the screen. It has also been posted in the chat room, and there is a 20% discount code that may be used until the end of the year that is shown on the screen and also on the in the chat room. Today's presentations, as Rena mentioned, we have Yuan Fang from Washington University School of Law. Then I'm going to present on the UNCITRAL model rules. And then James Clanchy is our anchor presenter on the LMAA's small claims procedure. So this should be a very interesting, hopefully, and informative set of presentations. And together with the session in December, hopefully will provide a great deal of insights and information to everyone who is interested in learning more about expedited international arbitration. Because as we all know, there is a great deal of let's say complaints about international arbitration and the fact that it tends to last too long and cost too much, which are interrelated aspects that expedited arbitration seeks to help alleviate. For today's presentations, there will be, so everyone knows, there'll be a question and answer period after all of the presentations are done. But if you have a particularly pertinent presentation, please use the raise your hand function at the bottom of your screen, or submit a question in the Q&A chat room. We already have one, so there is at least one question to be answered. And feel free to add them as you go along. Otherwise, when we reach the end, we'll have a general session for everyone. So with that, we'll start with Yuang's presentation, Expedited Arbitration in China, Identifying and Bridging the Gaps. And Yuan, the show is yours. And don't forget to unmute.
Yes. Thank you so much, Alan and Rena. So hello, everyone. It's really a great pleasure for me to be here today to present my chapter within this very important book project. The topic of my presentation, as introduced by Alan, is Expedited Arbitration in China, Identifying and Bridging the Gaps. So in the beginning, I'd like to talk a little bit about the research background of my chapter. So over the past decades, practitioners, scholars, and stakeholders have raised the criticism that international arbitration is departing from its foundation of expeditiously and efficiently resolving international disputes. And in response to the increasingly emergent demand for less time-consuming procedures, expedited arbitration has been introduced to the international arbitration community. And as one of the intellectual efforts to tackle the problems arising out of expedited arbitration, my contribution responds to such pressing issues uniquely from a Chinese angle. So I'd like to first provide you with an overview of the expedited arbitration practices of a representative Chinese arbitral institution, namely Beijing Arbitration Commission, Beijing International Arbitration Center, BAC-BIAC, in 2022. So among the over 8,000 cases accepted by BAC-BIAC in 2022, near 7,000 cases have adopted the expedited procedure, taking up roughly 80% of the cases in total. And most cases adopting the expedited proceedings have the amount in dispute not exceeding 5 million RMB. Meanwhile, the average time from filing the case to rendering the word for cases applying the expedited procedure at BAC-BIAC varies depending on whether the cases fall within the domestic or cross-border type. So for domestic cases, the average time required to complete the entire procedure was 174 days. And for international cases, the time required for the whole process was 202 days on average. And lastly, according to the long-standing practice at BAC-BIAC, which is, of course, beyond the single year of 2022, applications to convert arbitral proceedings between the expedited procedure and the ordinary procedure are extremely rare, with solely a few of them eventually approved. when we review this information and do some deeper analysis of it, we'll have the findings as follow. So first, given the 5 million RMB threshold, only a very limited number of cases adopting the expedited procedures have the amount in dispute over 5 million RMB at BAC-BIAC, indicating the amount in dispute already constitutes a barrier to the expansion of the application scope of the expedited proceedings at BAC-BIAC. And second, even taking into account the influence of the COVID-19 pandemic, the time actually spent for BAC-BIAC expedited proceedings is still disproportionately lengthy. And third, the 5 million RMB related requirements for the procedural conversion is an impediment to the prospective evolution of expedited arbitration at BAC-BIAC as well. And actually, the weaknesses of the BAC-BIAC expedited rules and procedures are also the shortcomings that the other main Chinese arbitral institutions have. So in the next couple of slides, we'll go through the expedited arbitration practices of those institutions. Last slide, please. Yes, thank you. So those institutions include like CTAC, CMAC, SCIA, and SHIAC. So concerning last slide, please. Yeah, I think it's a little bit. And the last slide. Yeah, this will. So concerning scope of application, we can tell from this chart that even though the major arbitral institutions in China allow for the agreement of the parties as the prerequisite for adopting expedited procedure, and as previously mentioned, the threshold of amount in dispute still constrains the application of expedited proceedings. Next slide, please. When it comes to time limits, as shown in this chart, so all the leading Chinese arbitration institutions have set a relatively short period of time for the expedited procedures, ranging from 2 to 3 months between the constitution of the tribunal and the word rendered. However, the core inquiry here is essentially how well the arbitral proceedings can strictly comply with the time limitations. Next slide. As for change of procedure, as you can see from here, basically the amount in dispute still plays a pivotal role in determining the permissibility of the change of procedure among all the main Chinese arbitral institutions, which actually reduces the flexibility of procedural conversion between ordinary and expedited proceeding. So the existence of all these drawbacks really calls for changes to the current expedited arbitration mechanisms in China. Next slide. So when taking a look at the global approaches to these issues, you may note that the ANSTRO here is not an arbitration institution, but the general idea is despite ad hoc and institutional arbitration are two separate regimes, they can support each other under certain circumstances. So clearly, Chinese arbitration institutions can not only learn from institutional arbitration, but also from ad hoc arbitration. And here, we'll first visit the application scope of expedited procedures. So the arbitral institutions like the SIAC, ICDR, and ICC adopt an approach that is similar to Chinese arbitration institutions, where the amount in dispute matters in the determination of the application of expedited proceedings. On the contrary, the ancestral expedited arbitration rules have nothing to do with the amount in dispute, but respects the consensus of the parties. So from my point of view, the approach adopted by the ancestral expedited arbitration rules is a better model for Chinese arbitral institutions compared to the approach adopted by the other three institutions. Removing the amount in dispute requirement provides more incentives for the parties to get involved in the expedited procedures, which will therefore facilitate the development of expedited arbitration. And indeed, the removal of the requirement of amount in dispute may not incentivize parties that always seek delay, but it provides a signal to the parties who seek to resolve disputes efficiently by encouraging them to use expedited proceedings without interference from dispute amount. Next slide, please. With regard to time limits, so the ancestral expedited arbitration rules and SIAC require that the word has to be rendered within 6 months starting from the constitution of tribunal. The ICC also has a requirement of 6 months, calculating the time period from the case management conference instead of the formation of tribunal. The ICDR, however, requires the word to be rendered within 30 days from the closing of the hearing or the final written submissions. So on the surface, the time limits set by the major international institutions for the expedited procedures are not stricter than those set by the Chinese institutions. Nonetheless, as formerly mentioned, the key issue is how well the arbitral proceedings will be able to conform to these requirements. In essence, the time limit for expedited procedures can be followed only if the arbitration participants jointly engage in the efforts of advancing the proceedings. So I think further measures should be taken by Chinese arbitral institutions to urge the obedience of the arbitration participants to the time limits for expedited proceedings. Next slide. In terms of change of procedure, different institutions in the world have adopted different approaches. So the first approach, which is adopted by the ancestral model expedited rules, as IAC and ICC, gives priority to the party's will in determining the permissibility of change of procedure. The second approach, adopted by the ICDR, emphasizes the importance of the amount in dispute in the determination of procedure conversion. So from my perspective, Chinese arbitration institutions should shift from the approach that is similar to what the ICDR adopts to the approach adopted by the ancestral model expedited rules, the SIAC and the ICC. Because to maintain the integrity of expedited arbitration, I do think that providing the parties the opportunities to opt out from the expedited proceedings is equally important to allowing them to opt in. And as a result, any requirement in relation to the amount in dispute should be removed from the existing expedited rules and procedures regarding determination of procedural conversion of Chinese arbitral institutions. So, in conclusion, Chinese arbitration institutions are encouraged to first remove their amount in dispute related requirements from the existing expedited rules and procedures, and second, seek specific measures to guarantee the arbitration participants' adherence to the time framework set for expedited proceedings. And third, secure the parties' autonomy of conveniently leaving the expedited proceedings. I further suggest that efforts should be made not only at the institutional level, but more vitally at the legislative as well, to highlight the significant role expedited arbitration plays in advancing arbitral efficiency. So the affirmation of the legal status of expedited procedure will be beneficial to the enhancement of expedited arbitration in China, which in the end is able to fuel the public's confidence in arbitration's promise of expeditiously and efficiently resolving disputes. So I think I'll stop here, and I very much look forward to the Q&A session later. Thank you.
Thank you, Yuan. Let's see if I can. So, I am now going to speak on the recently adopted UNCITRAL model rules for expedited arbitration. They were negotiated and adopted by UNCITRAL's Working Group 2 in 2023. I was part of that working group, and there was both a set of model rules and a model law that was that were adopted and approved. I'm going to talk about the model rules, which are basically the same as what's in the model law. And as Yuan mentioned, UNCITRAL is not an institution, but it is used a lot in ad hoc arbitrations, and obviously in those states that have adopted the UNCITRAL model law or model rules as their procedures to be followed in arbitrations. UNCITRAL was rather late in the game to develop a set of expedited arbitration rules. Didn't start discussing them or considering it until September of 2018. And as I mentioned, their basic arbitration rules, or their primary arbitration rules, are widely preferred and used in ad hoc arbitration proceedings. Because they were late to, if you will, the game of adopting or considering expedited arbitration rules, they had the opportunity to consider all of the different approaches adopted by other institutions. And they had the opportunity to create a gold standard, if you will, for expedited international commercial arbitration. And the question here is, have they achieved that sought after gold standard? And we'll give a very brief overview of the rules, and then at the end or in the Q&A, we can discuss whether they have in fact achieved the gold standard. Now, particularly as Yuan indicated, there are two primary approaches by institutions for application of the expedited arbitration rules. I define them as either a paternalistic approach, which is where the institution knows best. As Yuan indicated, that's a lot of or most all of the Chinese institutions. There's also the ICC, the Swiss rules. And by paternalism, where the institution knows best, I'm referring to those institutions where the applicability of the expedited arbitration rules are dependent on the amount in controversy. So, to use the ICC as an example, if the arbitration agreement was executed, I think it's prior to a date in 2017, it's a $2 million limitation, and if it was after that, it's $3 million. Of course, some of the issues that are obvious from having this paternalistic approach is that it's a amount in controversy that is just basically randomly set. The institution sits around, I'm sure there are councils, and they say, okay, what should the amount in controversy be? And they draw a line in the sand, if you will. But of course, that is, as I said, an arbitrary amount. I am certain that we all are familiar with or have had arbitration disputes, where the amount in controversy was very large, but the issues were very straightforward and basic. And there have been those where the amount in controversy was relatively small, but the issues were very important and very complex. And of course, if there is an amount in controversy as the hurdle, you have issues of, well, what about inflation over time and the need to adjust the amount in controversy? There are a number of institutions that have adopted the paternalistic approach that have had to change the amount in controversy multiple times since it was first adopted. You also have the question of what if the amount in controversy is stated in a currency other than the currency that the limiting amount or the set amount is fixed in. And so you have the variation of exchange rates. And of course, you have the party's ability to, if you will, play fast and loose with the amount in current controversy, either initially pleading an amount in a dispute below the maximum limit in order to get into the expedited arbitration rules and then trying to change that amount later on, or where they set an amount above the limit in order to get out of the expedited arbitration rules. So are those issues. The other approach is the party autonomy approach, that the parties know best. One example of an institution that has adopted that approach is the Stockholm Chamber of Commerce, the SEC. And as we will see here, it's the approach adopted by UNCITRAL. Some institutions, also as mentioned, have combinations where there is a set amount, but then the parties can opt out if they agree. As Yuan indicated, the LCIA, the London Court of International Arbitration, has conspicuously refused to adopt expedited arbitration rules. They rely on their Rule 14.4, which says that basically the tribunal and the parties can agree on whatever schedule they want. But of course, once a dispute has arisen, getting the parties to agree on a schedule may be difficult. So after considerable discussion and debate, UNCITRAL came down very firmly on the side of party autonomy. And so its arbitration rule, the application of its expedited arbitration rules required the express agreement of the parties. And that agreement is the sole criterion for determining application of the expedited arbitration rules. Of course, this too can be a limiting factor because unless the parties have agreed in advance, either as the part of the arbitration agreement or in the run-up to commencement of an arbitration, it may be very difficult, if not impossible, to get the parties to agree to much of anything. But you have to have an agreement of the parties to the application of the UNCITRAL expedited arbitration rules. Now, if you do go into the express lane of expedited arbitration under the UNCITRAL rules, there are a number of what I'll call key factors to make it fast, an express lane. Generally speaking, there will be a sole arbitrator, and this is consistent across a variety of institutions in addition to the UNCITRAL rules. There are shortened time frames for filings and responses, generally 15 days. The statement of claim and defense have to include all of the pertinent documents. So you need to basically have your case ready to go, both as the claimant or as the respondent. The ability to have document production with a Redfern schedule is very limited. Moreover, the tribunal can decide, and by tribunal I mean the sole arbitrator, can decide not to hold a hearing, or they can greatly limit the scope of the hearing to, for example, only oral presentations as opposed to actually seeing and hearing witnesses. Under the rules, the decision has to be issued about 8 months after filing the notice of arbitration, which is about 6 months after the tribunal is constituted. If there are exceptional circumstances that exist that lead to an extension of the deadline, then the process may last up to 11 months. But that is the end of it, basically. There was considerable discussion and debate in UNCITRAL Working Group 2 regarding the deadline for issuing a decision and what would happen if the deadline is not going to be met. And of course, the consequences are that the tribunal or the arbitrator loses their power to issue a decision. So there was the process incorporated into the model rules to allow for an extension of that deadline with exceptional circumstances. What makes the UNCITRAL arbitration rules somewhat different is that there are off-ramps. Consistent with the basic foundational policy of party autonomy, the parties can opt out of the expedited arbitration rules at any time, either in whole or in part, as long as they both agreed. So if they have initially said that they agreed to the expedited arbitration rules, they can decide to modify how the rules will be applied. They can change the deadlines, they can change the procedures. As long as there is an agreement, they can opt out in whole or in part. However, there is one approach or one method that is inconsistent with what I'll call pure party autonomy, and that is that one party, just one of the parties involved, can ask the tribunal, and again, typically the sole arbitrator, to decide that the expedited arbitration rules will no longer apply. And the if you will, guidance here is that they may no longer apply in exceptional circumstances. But this is an opportunity for one party, if the other side won't agree, to see if they can't get the tribunal to agree to opt out of the expedited arbitration rules. Now, the exceptional circumstances that may be considered by the arbitrator are listed here. They include the urgency of the dispute, the stage at which the request is made, the complexity, the amount in dispute, the terms of the party's agreement to expedite arbitration, and whether there's something that they hadn't anticipated that's come up, and the effects on the proceeding. In addressing a motion to opt out or get out of the expedited arbitration rules, the arbitrator doesn't have to consider all of those. She can pick on one or two and find that those are paramount reasons to drop application of the expedited arbitration rules, or she can, say, nope, they're all going to apply. The point is that the tribunal has that flexibility. The tribunal also has the flexibility to decide, in effect on their own, in the face of a motion to get out of the expedited arbitration rules, that only certain of the rules will apply or not apply. So the tribunal can modify the rules of the game, if you will, after it's already started, after play has already started. And they can do this even if one side objects. So this off-ramp really throws out the window the basic foundational principle on which application of the UNCITRAL expedited arbitration rules were created, which is party autonomy, because the parties aren't agreeing. And the fallback, of course, is if the tribunal does say, nope, for whatever reason, this dispute now should not be subject to the expedited arbitration rules, then the fallback is application of the standard arbitration rules. So has UNCITRAL achieved the gold standard? And I would suggest that they came close, but not quite, because the requirement of complete express agreement is likely to limit their use. As I mentioned, the likelihood of the parties to agree to expedite arbitration once a dispute has arisen oftentimes is slim and none has left the room. And so there has to be some, I think, for that to apply, if you're in an UNCITRAL ad hoc arbitration situation, or in a state where the UNCITRAL model law for expedited arbitration has been adopted, you have to put some thought into the arbitration agreement in advance as to whether or not you want to do expedited arbitration. The fact that parties can opt out of expedited arbitration will also limit its effectiveness or use, because oftentimes the parties may get involved in a dispute, and then for one reason or another, both of them may think, we just soon have this go on for a while, which of course may be great for the counsel, since, as we all know, if you give counsel time, that will be filled with billable hours. And the fact that one party can try to get out or limit application of the expedited arbitration rules may limit their effectiveness. That ability may lead to ancillary disputes, because if a party brings a motion to limit application, or to, if you will, force the other side to opt out of the expedited arbitration rules, there's going to be, a motion to that effect. There'll have to be a response. The arbitrator or the tribunal is going to have to make a decision, and that may lengthen the process as well. And it may lead to challenges to the enforceability of the award, because one can easily envision a situation where the parties initially agreed in advance, before there was a dispute, to application of the expedited arbitration rules. And then as the process gets going, one side says they want to opt out, and if that is successful, the other side may argue in a subsequent enforcement proceeding that, hey, this was against party autonomy. I will say that challenges to awards under the expedited arbitration rules have arisen based on the issue of we never agreed to this, or we didn't know we were agreeing to this. There are at least two decisions, both from in the Asia and Southeast Asia area. One refused to enforce the award based on lack of agreement of the parties. The other one did enforce it, saying, well, as soon as when you agreed to application of this institution rules, you agreed to them as in whatever form they were at the time. So the fact that you were surprised after the fact that you're suddenly in an expedited arbitration proceeding is not a basis to challenge the award or prevent its enforcement. So that is a very quick, very brief thumbnail, if you will, summary of the UNCITRAL expedited arbitration rules. One other fact that everyone should know is if the expedited arbitration rules aren't fast enough for you, UNCITRAL now has adopted and proposed for adoption a highly expedited set of rules. So if faster isn't fast enough, we can go faster, faster, faster. The highly expedited arbitration rules shorten the timelines even more. So you can go, you can put the pedal to the metal the pedal to the metal and really go fast under the highly expedited arbitration rules by UNCITRAL if you wish. So that is a quick summary of the expedited arbitration rules for UNCITRAL. And again, I look forward to the question and answers from everyone. Thank you. Now we move on to our last but certainly not least speaker, James Clanchy, who is joining us all the way from England. So James, the floor is yours.
Thank you very much. Well, I'm delighted to have this opportunity to talk about the LMAA's small claims procedure because it does deserve to be better known. It was neglected by UNCITRAL Working Group 2. I discuss the background to that in my chapter, and I was extremely pleased to have the opportunity to do that. And I'm very grateful to Alan and to Herman Verbist, the co-editors. But I won't be talking about the ins and outs of UNCITRAL Working Group 2 and its work with ICA in this presentation. I have a short space of time, and so in the spirit of expedited arbitration, I shall move to the issues which are the most important. And I would like to move straight to the next slide, please, Alan. I was pleased to see this quote. I wish I had seen it before I'd finished writing my chapter. I only found it afterwards. This is a quote from Johnny Vida, QC, who was a leading British international arbitration lawyer. He was actually American by birth. He had a fantastic international mindset. He was a very civilized man. He was also courageous intellectually and in the arbitration community. He wrote this question about whether the LMA small claims procedure couldn't be used in other kinds of international disputes in an ICC publication. As far as I'm concerned, he's a real hero for drawing other kinds of arbitration to the attention of institutional users. Next slide, please, Alan. Maritime arbitration is a fundamental component of international commercial arbitration. I would say it's even the quintessence of international commercial arbitration. That's because parties involved in maritime arbitrations are usually all in different jurisdictions. The contract is likely to have been performed in several other jurisdictions. The governing law is likely to be English, which is unlikely to be the nationality of either party. And the seat of the arbitration, well, it's likely to be London, but you could equally well have an English law chartered party dispute seated in Singapore, Hong Kong, or even New York. This photo on this slide is typical of the kind of picture that you will see in international law firms' brochures when they're talking about international commerce. But what is very often the case is that the big US and big UK law firms, which have relatively small international arbitration groups, have generally given up, if they ever did it at all, their maritime law practices. So whilst they very often have pictures of ships on their brochures, they very rarely actually deal with maritime arbitrations. And that's one of the reasons that maritime arbitration tends to be neglected, even although it is extremely significant. Number of LMAA arbitrations last year in 2023 was more than twice the number of ICC arbitrations across all sectors worldwide last year, if you look at the annual reports of both organizations. Next slide, please, Alan. Ad hoc arbitration tends to be neglected itself. The arbitral model law even found it necessary to remind people that arbitration can be ad hoc. I think we need to remember, actually, that the institutions are a modern invention. By modern, I mean basically 19th century. Maritime arbitration has a history in Europe that goes back to ancient Greece. Maritime arbitration has been practiced in the major maritime centers. Venice in medieval period, New York, importantly. It's been practiced for centuries, but institutions came along much later. The ICC is only 20th century, but they've really managed to win the PR battle. So the arbitral model law has to contain this reminder that arbitration doesn't have to involve a permanent arbitral institution. Next slide, please, Alan. But the arbitral model law isn't the only show in town either. Ad hoc arbitration in London has been an enormous success story. Most international commercial arbitration seated in London take place outside the institution. The institutions, basically the ICT and the LTIA, have less than 20% of all the international commercial arbitration seated in London. And one of the secrets of the success of London arbitration is quite simply statutes, the Arbitration Act 1996 and its predecessors, which provide for default procedures which are frankly faster than the arbitral model law. So you start off on a good expeditious foot. You don't need to go down the expedited route in most arbitrations. And just as one example, to appoint a 3-member tribunal, the default rule under the English Arbitration Act is that it should take no longer than 2.5 weeks. The LMAA's terms, that is, the rules that apply to most arbitrations, so bigger and medium-sized cases, they provide that claim submissions may be served as soon as the second arbitrator has been appointed. That means that time for the defense starts running after 2 weeks. That's much faster than under institutional rules, and it's much faster than under the arbitral model law. Alan, the next slide, please. The LMAA publishes rules for arbitrations in general and for small claims as well. It does not administer arbitrations at all. It plays no part in any of the arbitrations which go under its rules. The most that it ever does is that its president will appoint an arbitrator in default if the parties have agreed, which can include under the small claims procedure. Otherwise, the LMAA plays no role at all in an arbitration. And this is what it says on its website. You'll see that it is simply not an institution. What it offers is what Sir Geoffrey Voss, the Master of the Rolls in England, would call disintermediated justice, a form of justice which involves no intermediaries no one stands between the parties and the arbitrators. My final slide, please, Alan. The LMAA realized back in the 1980s that although arbitration by 2 or 3 arbitrators under the English Arbitration Act can be quick, for smaller claims, not necessarily urgent claims, for smaller claims, typically dealing with accounts at the end of a charter party, for example, it could make sense to have a sole arbitrator, and it could make sense to have a simple procedure which could be dealt with in less than 6 months. So it came up with the small claims procedure in 1989. As Alan rightly said, Unsichtbar was a bit late. But it is a pity that Unsichtbar Working Group 2 didn't look at the long and successful history of the LMA small claims procedure, because it has been dealing with between 150 and 200 cases a year ever since 1989. And it has been tweaked, it has been amended over that period to deal with practical issues that have arisen. It is an extremely simple procedure. Features include the fixed fee for the arbitrator, which is paid upfront at the beginning by the claimant. No messing about with advances on costs and who should pay them. There is a cap on the recoverability of fees of lawyers involved, and very often lawyers aren't involved. It's a documents-only procedure. There should be no hearing. It is extremely important to note that there is no CMC, no case management conference, and no terms of reference. The simple rule for a fast procedure is don't consult the parties. Don't allow parties to start inventing different kinds of procedure that might be appropriate. There's a procedure agreed in advance and they must stick to it. This is a formula that works very well for the LMA small claims procedure. So it contains a tight timetable for the submissions, and there are word limits on those submissions. Evidence is usually simply documentary. That these days can include transcripts of WhatsApp or WeChat conversations. It's extremely rare for the witness statements to be submitted, and experts' reports can only come in if specifically permitted by the arbitrator. There's no disclosure. And the general rule is that the award should be produced within a month of the close of submissions. Now, there are off-ramps. There can be exceptional cases. The arbitrator can decide that the case is, in the words of the SCP, because of its nature or weight, that it should come outside of the small claims procedure. Extremely rare for that to happen, but it can happen. And the arbitrator can depart from the procedure in exceptional cases. But generally, this is a procedure that works well. Parties quite rarely settle because once they've decided to go down this route, it's not going to take very long and the fees are fixed. It has a good track record and it deserves more attention. I'll be very pleased to answer any queries about it. Thank you.
Thank you, James. And we are now to the Q&A session and also any further discussion. So I encourage the attendees to submit their questions through the Q&A function or otherwise. I at least here can't see anyone else's screens. So please do try to use the Q&A function that is available at the bottom of your screens. There is several questions already that we have to consider. And just to sort of sum up what we've heard is we started with Yuan's discussion of the expedited procedures that are typically followed in China and with the Chinese institutions. And, Yuan's, if you will, plea or recommendation that the use of, if you will, the paternalistic approach of a set limit to be in or out of the expedited arbitration rules should be changed. I then talked briefly about the UNCITRAL model law and its decision to adopt a firmly party autonomy approach, although with off-ramps. And then we heard from James, and I will readily admit, it didn't come up during the discussions at UNCITRAL Working Group 2, the LMAA's procedures, which, what he mentioned in passing, and maybe he can just clarify this, is used far more frequently than any of the other institutional rules. I mean, James, how many LMAA arbitrations have there been in the last couple of years using the expedited rules compared to other institutions, if you've got that information handy, just to pass on?
I don't have the precise figures in front of me, but generally the number per year has been just short of 200. Last couple of years, it's been a little bit lower. One reason that's given for that, actually, is that, and I should perhaps have mentioned it, but there's usually a cap of $100,000, really quite small. And that cap is thought to be rather too low at the moment, because freight and hire rates for ships are that much higher. And so claims are generally falling above that level. So that's one reason why. But as for comparisons, I have to say it's quite interesting. Again, I don't have the exact numbers in front of me, but I believe that last year the ICC's EPP, expedited procedure, actually overtook the LMAA small claims procedure in terms of numbers of cases. It's really rocketing ahead.
All right, thank you. So the first question that we have, and hopefully I will, if you will paraphrase this correctly, it has to do with the question of mitigation and collateral payment in a expedited arbitration. And the person who raised this question indicates that they saw a discussion on social media about a recent commodities English case. And the question was whether the seller has mitigated or failed to mitigate the damage done by the carrier. This was in a maritime case, was something that could be raised in the context of expedited arbitration. So since it has to do with maritime disputes, I'm going to throw this to James, and hopefully you can provide some enlightenment in that question.
Well, no, this is a very interesting question, and I'm grateful to you for raising it. She's alluding to a recent English court judgment, which is a little bit controversial. And I think that's the point of her question, because the issue here is whether something as sensitive and difficult as this, including in relation to evidence, could be handled in an expedited procedure. The short answer is yes. In principle, no question of law should be too difficult to be dealt with in an expedited procedure. The issue is how good the answer will be, given that there will be limited submissions, limited evidence presented. Did recently have a case in the LMA small claims procedure, which involved a little explored area of English law. And I was rather worried as to whether we really were going to be able to deal with it properly. But the parties just decided that they had made the submissions that they could within the limits that they could. And it was just for me to do the best I could. I had very few authorities. I had hardly anything really to go on. but they just wanted a decision because they'd not managed to settle. So long as you don't have a right of appeal, you're not going to have the legal arguments rehearsed in the courts. So it's a way of dealing with such a dispute, however difficult it might be.
All right. Thank you, James. Hopefully that answers the question. And if not, please raise a follow-on question in the Q&A. So the next question is for Yuan, and that is, what is and that has to do with the situations in China where the UNCITRAL expedited rules might be adopted or followed. And so the question is really, what is the future of ad hoc arbitration in China as an alternative to the institutional arbitration that you discussed and raised here?
And thank you very much, Alan, for the question. So Article 1.5 of the UNCITRAL arbitration rules has incorporated the expedited rules, which are, I think, presented as an appendix to the UNCITRAL arbitration rules now. So in this regard, the UNCITRAL expedited rules are to be adopted by a Chinese institution only if that institution agrees to adopt the UNCITRAL arbitration rules first. And as I know, there are basically two situations where ad hoc arbitration rules are possibly to be adopted by a Chinese institution at the current stage. In the first situation, ad hoc rules are adopted by a Chinese institution that functions as the administrative institution governing the arbitral proceedings. In the second situation, ad hoc rules are adopted by a Chinese institution that merely provides supporting services for the arbitration proceedings. While the first mode is somehow acceptable in China, the second mode can be sort of controversial, primarily because of the uncertain legal status of ad hoc arbitration under Chinese law. As you may know, the present PRC arbitration law recognizes only the legality of institutional arbitration and doesn't say anything about ad hoc arbitration. Nevertheless, ad hoc arbitration is gaining popularity in China. Actually, it has been integrated into the consultation draft of the revised PRC arbitration law released, I think, just several days ago. Although this draft revision hasn't been passed yet, it's very likely that the finally adopted version will legitimize ad hoc arbitration. And aside from legislation, there are other ongoing efforts to promote ad hoc arbitration in China. For example, the institutions like CMAC and CIAC have already adopted their rules or guidelines for assisting ad hoc arbitration. The CTAC may also provide services for ad hoc arbitration, and there are also the Hainan Free Trade Port ad hoc arbitration rules adopted earlier this year, etc. So all these latest developments show that ad hoc arbitration will be more broadly applied in China, perhaps in the not distant future. And of course, that potentially also includes the more frequent adoption of the UNCITRAL arbitration rules, the expedited rules, and as well as perhaps the proposed super fast expedited rules in the future. Yeah. Thank you.
Thank you, Yuan. The next question comes from someone who is attending from Nigeria. And their question is, how can to paraphrase it, how can expedited arbitration help or be used in multi-party arbitration where the gateway provisions are based on party autonomy? So if there is more than just a two-party dispute, how can expedited procedures be used? And if it's all right with my two co-presenters, I'll take a first stab at an answer there. The answer is, I think, several ways. First off, obviously, if you can get all of the parties to agree to expedited arbitration, that can occur in obviously two ways. One is once the dispute has arisen or is on the horizon, getting the parties to agree that if the dispute or as a result of the dispute going to arbitration, that expedited arbitration rules could be applied. Now, if the administering institution is an institution that has set the or is following the paternalistic approach of setting an amount in dispute, that may, depending on how much is in dispute, put the arbitration into that institution's expedited arbitration rules. So, for example, under the ICC, if the amount in dispute is $3 million or less, you're going to the expedited arbitration rules. If assuming the parties, all of them, have agreed to ICC institutional arbitration. Another way, and this is one that I suggest everyone should consider, is to build into the arbitration agreement a time limitation. You can in effect create expedited procedures by setting a deadline or a time limit by which the final decision has to be rendered. That, of course, requires a couple of things. First, foresight and forethought, and more than what I typically see, which is as some major agreement is being finalized at the 11th hour, the counsel who are negotiating the agreement say, oh, we need an arbitration agreement clause in here. And they either can, pull something, some form or boilerplate provision in offline or online and put that in, or they can draft something themselves and sometimes come up with a clause that is incapable of being followed or applied. Or they could actually ask individuals who are involved in arbitration and get their thought. And I have on myself on more than one occasion suggested, look, you may not want to be in the full-on expedited arbitration rules of an institution or the UNCITRAL model laws. So instead, put in a deadline by which the arbitration award has to be rendered, whether that's 6 months, 9 months, or a year. It is invariably or typically going to be faster than it might otherwise be. And that does put a hard stop on getting the process done. Keep in mind that the whole, if you will, raison d'etre for expedited arbitration is to a great extent to return commercial arbitration to its foundation, which was a fast and inefficient, cost-effective way of resolving a commercial dispute. So I think that's another way to get expedited arbitration procedures in use in multi-party arbitration. James or Yuan, do you have anything that you might want to add there?
Only to say that indeed, it's a very good question. The LMAA small claims procedure would not be well suited to multi-party arbitrations. In my chapter, I do mention the problem of chain contracts and arbitrations being held up and down a line of contracts, which themselves might not be expedited. The small claims procedure sort of falling in the middle somewhere, it can be problematic. I think probably the UNCITRAL expedited arbitration rules are more flexibility, are more suited to multi-party arbitrations.
Okay, Yuan, anything you'd like to add?
Nothing else to add here, Alan.
Okay. The next question we have is directed toward James as well, and that relates to something, I'm going to paraphrase this, which is, I think an issue in international commercial arbitration, and that is, this question in particular is, what are the prospects for settlement negotiations or mediation during an expedited arbitration procedure? And that raises an issue that I think is endemic to all international commercial arbitration, in that once you, if you will, buy the ticket on the train, you are going to ride it all the way to the end to the last station. There's not a a set or clear opportunity for the parties to try to resolve the dispute after it has arisen or after an arbitration has been filed amicably. And that may be even more the case in expedited arbitration. So, James, what are the prospects for amicably or unamicably resolving the dispute through settlement discussions or mediation in the context of an expedited arbitration procedure?
Well, I think that the prospects are lower than in a regular arbitration procedure, really for the reasons that you've given. As I've just indicated, if a claimant under the LMA small claims procedure has paid the upfront fee, and it's already probably spent a bit of money on lawyers to get its claim submissions done, it's already spent the costs, and it may as well await a result unless it's nervous about that. That tends to mean that actually small claims procedures are rarely compromised. And we do see a high proportion of awards. It's one of the secrets of the LMA small claims procedure success, in fact, that so many cases go full term. Having said that, my very first SCP case as an arbitrator did settle. And I think what did help there was that the parties' minds were concentrated by the fact that there was an expedited procedure on foot. If they were going to settle, they needed to do it quickly. I remember I had to make a couple of procedural orders quite early on, and those, I am told, help the parties to get round the negotiating table. It can happen. And under the SCP, if a case does settle early, then the arbitrator is expected to return some of the fee to the claimant, and that does happen.
Thank you. So the next question here is for Yuan, and that relates to the length of expedited arbitration in Chinese institutions. And that is, the question is why, if it's supposed to be expedited, does the expedited arbitration process with Chinese institutions take longer than anticipated? What makes expedited arbitration in China not expedited?
Yeah, thanks for your question, Alan. If you take a closer look at the expedited arbitration practices of Chinese institutions, you will note that the arbitration participants are generally able to comply with the time framework set for them for the time period between the constitution of tribunal and the word rendered. So for that period of time, the compliance is actually overall satisfactory. It's actually the period of time prior to the formation of tribunal that can be more problematic in reality. I don't know if this is also the case in other jurisdictions, but at least in mainland China, it is usually the case manager, or that's the secretary, who pushes the proceedings forward before the tribunal is constituted. But as you might be aware, the number of cases accepted by Chinese arbitral institutions has rocketed, particularly over the past several years due to various reasons. So, for example, the institutions like SCIA and BAC have each accepted over 12,000 cases in 2023, which is an incredibly high volume, especially as compared to the primary global institutions. So this means the case managers at these arbitral institutions now have to handle a large amount of cases assigned to them from their institutions. Even though most cases have adopted the expedited procedure and are not complicated, the fact that there are so many of them all at once still inevitably affects the efficiency of the arbitral process. So I guess you might be curious. So why not just hiring more people to get the job done? Well, arbitral institutions will normally do a cost-benefit analysis when navigating such issues, of course. So if saving human resource costs outweighs the benefits gained from expediting the proceedings, then probably they will choose not to recruit more case managers. With that said, I insist that at the end, they still have to figure out a way to solve this problem. Otherwise, this will sooner or later impact the sustainable development of the arbitral institutions in China. So yeah, this is my response to your question, Alan.
All right, thank you. And I want to kind of throw a version of this to James with his vaunted LMAA procedures. And that is, and he knows where this is coming because of discussions that we've had between ourselves, is what are the instances or the chances of an LMAA procedure turning into something that isn't so expedited? In other words, getting off track. And is that something that the arbitrator alone decides? Can the parties decide that, or what? Because I think you have an example recently of where you ended up taking longer than might have been provided for under the LMA rules.
Thanks. No, it's a good question. The final paragraph of the LMA small claims procedure, headed general, gives the arbitrator the discretion to amend the whole of the procedure above in what are called exceptional cases. And there's no definition of exceptional. I have invoked that right a few times, actually, in circumstances where I don't think that the parties would have been at all surprised, in situations in which it appeared that a further round of submissions was going to help. That's usually the situation. Occasionally, there's some additional evidence which has in effect been called for by one party and which can then be provided. So it is possible to depart from the procedure. Whether you're going to take it out of the small claims procedure altogether, though, and make it into an ordinary procedure, that's much more controversial, but it's also possible. There is an off-ramp in paragraph 9C of the small claims procedure, where it says that in any case where it is determined or agreed that, in other words, either the parties agree or the arbitrator simply decides that because of the nature and or weight of a case, the small claims procedure is inappropriate and shall not be applicable. Then it goes on to say that the arbitrator shall retain jurisdiction. And it then goes on to say that he may keep the small claims fee. So that is extremely rarely invoked. And in one or two cases where it has happened, and that's been recorded in anonymized summaries of those awards in Lloyd's Maritime Law newsletter, there has been quite a fuss in the London maritime arbitration community, disapproval of the arbitrator for doing this. It's generally considered that even in what looks like a complicated case, the arbitrator should just deal with it within the parameters of the small claims procedure and put up with the limited fee and get it done within the time required. But there certainly are some cases which may be of relatively low value, but which involve complex facts or complex technical expert evidence. And in those cases, you can see why occasionally an arbitrator might want to go off ramp.
Thank you. Our next question comes from someone who is attending from Belgium. And in the interest of full disclosure, it is my co-editor for the book, Dr. Herman Verbist. He asks, are expedited arbitration proceedings rather for younger or new arbitrators or for more experienced arbitrators to deal with? And that's a very good question because it goes to, I think, part of the problem that exists with international commercial arbitration at this time, because the complaints or concerns that have been raised for, ever since the beginning of the Queen Mary Law School surveys, is that it's taking too long and it's costing too much. And that's the responsibility, I would contend, of all of the stakeholders, the institutions, the parties, the council, and the arbitrators. And one of the things that you often see in not often, almost invariably see in international arbitration, is that it is the same group of individuals who are being appointed as arbitrators, whether individually or as part of a tribunal. And that can lead to the situation, which I'm certain everyone has experienced, where you get arbitrators, appointed, or a tribunal appointed. You're ready for the final hearing, or everything has been, the final hearing has occurred. There have been the final submissions. And then you either before or afterwards, where one or more of the arbitrators says, well, I'm not available to have the final hearing for some amount of time, months after everything is supposedly ready. I have had that experience. I've also had the experience where everything is submitted. The tribunal is supposed to render the decision within 30 days. And on the 29th day, the chair or the arbitrator says, I need more time. I'd like another 30 days. And you can't very well say no unless you're potentially going to get what happens. Or what occurs as a result of being the recalcitrant party. Or I've had where they ask for initial 30 days, then they ask for another 30 days, then they ask for another 30 days. So the question is, are expedited arbitration proceedings for younger and newer arbitrators or for more experienced arbitrators? I would say the answer is yes, which is, there are younger arbitrators and new arbitrators that are perfectly well qualified to hear and decide expedited arbitration proceedings. They have all of the skills, they have all of the background and knowledge, and they certainly can handle it. And in many instances, they may be able to handle it expeditiously and with more attention than if you get an arbitrator who has much greater experience but is serving on a number of tribunals or has a number of disputes that they have to address at the same time. So their attention is distracted. Whether it is a expedited procedure where there is a fixed fee up front, such as with the LMAA, or some other, if you will, payment process for the tribunal, I think what you want to get is, or hope for, is an arbitrator who is going to pay attention and is going to follow the guidelines and be able to meet all of the timelines for the schedule. And if that is a newer arbitrator or someone who is younger, but perfectly well qualified, it's the perfect opportunity, and they should be considered for the appointment. Or if it is a particular case that demands someone with a great deal of experience, that's fine, but you have to make certain that they really and truly do have the time available to devote to resolving the case. James or Yuan, anything else you'd like to add to that question?
Well, I would agree with the points you've just made. As far as the LMAA is concerned, when the president of the LMAA is called upon to make an appointment of a sole arbitrator under the small claims procedure because the parties haven't agreed on an arbitrator themselves, then the president will look at the lists of full members of the association, who tend to be senior, very experienced arbitrators, but also the aspiring full members who are arbitrators at an earlier stage of their career, whatever their experience of shipping and of shipping law might be. And very often, in fact, the president will appoint from the aspiring full members. And just to echo what you were saying, newer arbitrators, very often with smaller caseloads, have more time to devote to the case, and B, they have the enthusiasm to do a good job which can be very valuable. Having said that, it also needs to be recognized that in some particular areas of disputes, it can make sense for an experienced arbitrator to be appointed because they will be able to deal with it quickly. And what we do see in the LMA small claims procedure sometimes is that a very experienced arbitrator will write an extremely short award because they know what the answer is very quickly, which is partly what expedited arbitration should be about.
Thank you. Yuan, anything that you'd like to add there on what sort of arbitrator should be appointed for expedited arbitration?
Yeah, well, actually, I'm not an arbitrator yet, so of course, apparently I'm not at the best position to respond to this question. But if I am hoping to get the opportunity to become an arbitrator perhaps in the future, and indeed, I've learned a lot from you two today. Thank you.
Okay. All right. We have just a few minutes left. I do want to raise one issue which is out there invariably, and that is the due process paranoia that exists and that very often is the elephant in the room, if you will, in the context of expedited arbitration. And I merely want to say that sadly we didn't get a direct question on it, but I just want to say that I think due process paranoia is just that. It's a paranoia and it's not real. I have made some effort to try to find cases where, in fact, an award was overturned based on a failure to provide one party or the other fair due process, a full and fair opportunity to be heard or to present their case. And I've only found two instances which were involved rather extreme facts. So to the extent that any of our attendees are concerned about due process paranoia, because of course arbitrators have pounded in their heads when they are being trained that you've got to issue an award that's going to be enforceable. And then that's just overblown and really isn't a valid concern, or it shouldn't be. So with that, we're down to the last couple of minutes. Unless James or Yuan have anything left, I will give it back to Rena to summarize and to tell us about upcoming events.
Thank you, Alan. Thank you, Yuan, James. Thank you for sharing such invaluable insights. We've learned a lot today, and your expertise has shed light on the evolving landscape of arbitration and the practical steps towards efficient, effective dispute resolution. So on behalf of CIArb, NAP, and ADR community, we're grateful to you for sharing your knowledge. A big thank you also to all our participants for joining us and for your thoughtful questions and engagement. And we hope today's discussion has provided you with useful perspectives and tools to apply in your own practice. We're going to see you again on December 4th, hopefully. And until then, thank you again, and look forward to seeing you at our future events. Have a great day, everyone.